Hey, welcome everyone. Let's go on the record. Today is Wednesday, July 8th, 2021. This is 4th District Court, Division 10. We're in the matter of Assumption Construction doing business as Eckles Paving versus Matt Baker, 2004-00334. Let's see, we have Mr. Tracy on behalf of plaintiffs. Is it Mr. Olson?
Craig Olson is the representative for Eckles Paving.
All right. Well, we're here for a writ of execution hearing. Have we been able to resolve anything?
We have not. We have not spoken with Mr. Baker. I see he's on the line here.
I noticed we did get a satisfaction of partial judgment that was filed on the 28th of June, so that may take care of some of the, at least one of the issues that was.
It does, Your Honor. Mr. Baker pointed out that there had been a garnishment of a bank account. He was correct. So we have adjusted the amount owing on the judgment to reflect the garnishment. The notice of partial satisfaction of judgment reflects the current amount owing, which we calculated as of today at $16,507.16. I will note that the judgment that was entered, and just for your information, Your Honor, if you haven't seen this on the docket, this was not a default judgment. This was a motion for summary judgment that was granted. And the judgment that was entered by Your Honor in September of 2020 also allows for attorney's fees incurred in collecting the judgment. So we would like to, before we get the amended writ of execution, file a declaration and update the judgment for the amount of fees that we've incurred in trying to collect it.
All right, are you there, Mr. Olson?
Well, Mr. Olson is my client, Your Honor.
I'm sorry.
Mr. Baker.
Mr. Baker represents himself?
Correct.
Mr. Baker, are you there?
Yes, I am, Your Honor.
Is there anything that you wanted to say today or let me know?
Anything here, or are we going to, I mean, I'm not familiar with these writ of execution hearings. Are we going to go over some of this information, or is that an open-ended question?
So here we have a judgment that's valid. It hasn't been ever set aside. So we have a judgment, and then we have a writ of execution that came from that judgment. And so you filed a request for hearing saying that I think we have an irrevocable trust here that we're involved with. So I want to know why you think the writ of execution shouldn't stand or shouldn't go forward.
Okay. Well, I guess for the reasons that I enumerated in my request for the hearing, first of all, dispute that the debtor in question here is myself. Secondly, I don't have any ownership interest in the real property that they're attempting to execute the writ against.
All right. Anything else?
I believe that's it.
All right.
Your Honor, if I could, may I address that? So as we put in our response, this property was held clearly in the name of Matt Baker individually. The warranty deed shows that he transferred that property to his revocable trust. This is not uncommon. Debtors try to avoid creditors by transferring it into revocable trust. That doesn't work. Under Utah Code 75-7505, the law clearly provides that, quote, during the lifetime of the settler, the property of a revocable trust is subject to the claims of the settler's creditors. In this case, we can see from the warranty deed that this was a transfer from Mr. Baker individually to Mr. Baker as trustee of his revocable trust. Therefore, his objection on the ground that it's held by his trust is not valid and should be overruled, and we should be allowed to go forward with this execution.
All right. Thank you. Mr. Baker, anything else?
Yes, Your Honor. First of all, this transfer happened long before any action was pursued on this. So his claim that this was an attempt to evade a debt is incorrect. And secondly, I'm not an attorney, so I don't know all the ins and outs, but I know I don't have any ownership interest or stake. Just because I'm merely a trustee, I am not a grantor as I understand the term is used in revocable trust. I have no ownership interest in the trust. I'm merely a trustee of the trust. The property, I have no ownership interest or stake in.
Okay.
Well, Your Honor, the warranty deed that was submitted, they transferred the property on November 20th of 2019. As you know, Your Honor, if he had transferred it to his daughter, we would be doing as a fraudulent transfer action. We don't have to do that because he didn't transfer it to his daughter or another family member. He couldn't get around paying the debt by doing that either, but that's not what happened. The warranty deed is from Matt Baker, grantor. When he says he's not the grantor, he is the grantor, and the grantee is Matt Baker and Stacy Baker, trustee of the revocable trust. So it clearly is covered by the statute. This property is subject to, is available to creditors.
All right. Anything else, Mr. Baker?
Yes, Your Honor. Immediately after filing that as a grantor, any interest as a grantor was abandoned, and I've become merely a trustee of the trust. I have no ownership in it as a grantor. My understanding from the attorney who prepared the documents was I had to transfer any interest in that, but then I abandoned any interest or rights as a grantor, and I'm only a trustee of the trust and nothing more.
Okay. Well, you had another, so you're not disputing any longer that adjustments have been made. Looks like that's been taken care of. Mr. Baker?
Well, I don't believe that I've seen anything in regards to adjustments being made.
Okay, there was a notice of partial satisfaction of judgment that was entered June 28th. In that document states there was a judgment entered September 2020 in the amount of $21,753.70, and that it has been partially satisfied, giving you credit for payments in the amount of $7,704.05, making the remaining amount of the judgment $16,507.16 with interest.
Okay. So apparently it looks like that has occurred, but I'm going to take a step back here and indicate that I'm not even the debtor here that's indicated here. So they've got the wrong individual. But putting that aside, like I said, this property was.
That's important. That what you just said.
Okay.
You're not the Brandon or Matt Baker that summary judgment was issued against.
I'm not the Matt Baker that's listed in here. No.
Okay. Let me see here.
Well, Your Honor, we took a supplemental order and examined it on his property. And he was the Matt Baker that was in the judgment. He's the Matt Baker that we talked to at the supplemental proceeding.
Well, I don't know. Let's see your, do you have video, Ms. Rose or Mr. Baker? Did you do the supplemental order, Mr. Tracy?
I did not. Bradley Johnson did. That he's in my office here. He's in a deposition, but I could get him. Craig Olson is on the line. I think Craig Olson recognizes him.
Yeah, I mean, I met Mr. Baker a couple of years ago. I'm sure I could recognize him if I could see his face.
Do you have video, Mr. Baker?
I don't. I'm not sure when Craig Olson's indicating he met me. I don't know him.
Well, without video, I can only assume that you're who they're asking to garnish or to execute on.
You can only assume that?
I'm sorry?
You can only assume that?
Yeah, because I don't have your video. I don't know.
Your Honor, it's